Finally, we have Alan Mendenhall of Troy University. The title of his paper is Libertarianism and the Common Law. Alan Mendenhall is Associate Dean and Grady Rozier Professor in the Sorrell College of Business at Troy University, where he directs the Manuel H. Johnson Center for Political Economy. All right. Thank you.
Well, thank you. I step up to the microphone at an extraordinary moment in human history. There are 10 seconds left in the Alabama-Texas football game. And an unranked Texas, Alabama just scored. So Alabama is now up 20-19 over Texas with 10 seconds left. This is pretty incredible. But what I'm supposed to be talking about is libertarianism and the common law. Libertarians have long appealed to the common law as an exemplary form of human order. Murray Rothbard stated that the common law has often been a good guide to the law consonant with the free market. Elsewhere, he claimed that the justly celebrated common law was developed over centuries by competing judges applying time-honored principles rather than the shifting decrees of the state. My good friend Todd Zwicky claims that there is a long and deep affinity between libertarianism, law and economics, and the common law, and he adds that libertarians clearly appreciate the pivotal historical importance of the English common law in the historical emergence of a free and commercial society. So this talk describes elements of the common law that illuminate its libertarian attributes and tendencies. I'm going to suggest that the common law has epistemological importance as a form of bottom-up ordering based on traceable patterns of human behavior over time. The common law transmits to future generations accumulated knowledge in the form of written rationale, facts, and decisions embedded in the opinions of innumerable judges over time and dispersed across jurisdictions. Cases in the aggregate supply important data and guidance to future generations, containing within them more information than any one mind or group of minds could alone possess. The common law, then, is a vast deposit of the evidence, argumentation, reasoning, inference, and interpretation that enable the ordered flow of human experience. It is neither static nor monolithic, the product of countless judgments and processes that are mutually constraining or enabling according to the circumstances. The common law is a system or a framework within which rules and principles evolve gradually and by slow degrees. The constant filing and disposing of cases, the numerous and diverse opinions that resolve complex situations, the cumulative reliance of lawyers and parties on past decisions and settled rules, all of these create a synergy out of which emerges binding consensus regarding the operative rules and principles that control human behavior within a specified field of business or conduct, or within a prescribed jurisdiction. Each jurisdiction is an experiential proving ground for the validity and practicality of judicial determinations regarding acrimonious disputes. Divergent paths of case precedent may be causally dissimilar or unconnected until an unexpected fact or chain of events yields their improbable intersection. As they progress through their career, rules modify not by prescription or design, but by chance responses to unplanned precipitating actions and events. In each case, a judge exercises his or her agency and reason to render a judgment or ruling, but the agglomeration of those judgments and rulings does not and cannot represent a single, uniform purpose or intent. Those judgments and rulings settle into patterns of recognizable rules that reflect the governing values and cultures of a people within a circumscribed territory. Rules passing through cases are plastic and malleable, but only within fixed parameters established by custom and precedent, and only when factual contexts or exigencies necessitate reasonable adaptation. Radical departure from precedent rarely occurs. The common law changes gradually and incrementally, tending to preserve rules if only by tinkering with their application. Think of a circle having clear boundaries within which rules enjoy play and fluidity to address difficult problems. That circle is, in this example, a jurisdiction, the outer limits of the governing authority. Institutional restraint, customary practice, seasoned protocols, and procedural habits limit the elasticity of rules within the jurisdiction. By analogy, a poet adhering to the traditional sonnet form, which you could think of as a jurisdiction of sorts, takes creative liberty with diction, tone, metaphor, alliteration, assonance, and so on, while adhering to the strict overarching structure that makes the sonnet a sonnet. Just as jurisdictions display different features, so sonnets display different rhyme schemes or metrical feet. No two jurisdictions are the same. No two sonnets are the same. The ideal jurisdiction, in my view, has small dimensions, modest scope and scale, and offsetting authorities, for example, an executive, legislative, and a judicial branch, but that's a matter for another talk. Judges are parties considering the rule governing immediate circumstances may, for the sake of argument or persuasion, suppose or suggest that it is an unchanging, immutable fixity, when in fact it is a combination of disparate factors and elements. Neither the judges nor the party to the case know the original causes of the operative rule or principle at stake in a dispute. All they know is that the rule or principle remains authoritative and precedential. When a judge reaches a decision, he or she doesn't survey the entire field of history he doesn't survey the entire field and history of law before issuing a decision, ruling, or opinion. He looks only to those germane prior decisions, statutes, and constitutional provisions needed to dispose of a case reasonably and expeditiously. Judges do not require an exhaustive historical count of the governing principle or mastery of its philosophical underpinnings to know how and whether to apply it in a particular context. That's because the common law system grew out of habits and practices that, through succeeding eras, built workable institutions to manage and mediate human complexities. When an HOA, a homeowners association, sues a homeowner for breaching the neighborhood covenants, it doesn't trace rules back to Henry II before serving the alleged offender with a complaint. The homeowners association, working with its lawyer, simply knows what to do procedurally to seek the redress, remedy, or relief that it desires. The long inheritance of repeated error and illogicality can trap society in a quiescent state of unconstructive, ineffectual inertia. A static rule that is good and right is one thing, but a static rule that is bad and wrong is quite another. A society accustomed to the application of nested rules and principles naturally resents their sudden alteration or displacement. The common law illustrates a conservative approach to the reality of necessary change. The common law is not an impersonal, deterministic product of natural forces divorced from human agency. Rather, it is the sum of human agency, the product of multiple actions and intents across an expansive network that in its totality defies full comprehension by limited human faculties. No individual, not even a collection of individuals, could know the entire common law, which, after all, is the deposit of all legal knowledge recorded in text for reference, study, explanation, and counsel within that jurisdiction. Here we might recall Hayek's observation that knowledge of the circumstances of which we must make use never exists in concentrated or integrated form, but solely as the dispersed bits of incomplete and frequently contradictory knowledge which all the separate individuals possess. Hayek had in mind the problem of a rational economic order, which is akin to and as problematic as a rational legal order. Both orders are unknowable in full. They possess within them too much information for individual humans, even numerous groups of humans, to comprehend, but they regulate human behavior without the impetus of a single design. Hayek's theory about pricing being set by local and dispersed knowledge applies as well to those cultural values that shape and inform rules and principles. How wonderful and beautiful that the uncoordinated actions of innumerable people can contribute to a coherent process that developed not by central design, but by mutual adjustments to urgent problems requiring legal solutions. These adjustments multiplied to form a nameable system, the common law, a composite of interrelated, binding legal opinions that govern human behavior not according to an abstract, unified plan, but arising out of a multiplicity of cases, each of which involves an intimate understanding of intricate facts and immediate circumstances. So what I've spelled out is the historic understanding of the common law, which may not be what we see in an age of massive centralized government and constitutional superstructure, but it is an ideal toward which libertarians could still aspire. Thank you. How did the game turn out? Anybody know? What? Texas didn't make it. Ah, man. Okay. Yeah, questions?
Do you draw a distinction between judge-made law, which is what David Friedman calls common law, judge-made law, on the one hand, and ancient and customary usage on the other?
Not necessarily. Under the historic understanding of the common law, what judges are doing are they're responding to antecedent circumstances and conditions. So customs, traditions, values, they respond to the rules that are already in existence, the rules and normative orders that are antecedent to any government promulgation.
Well, this antecedent and precedent thing can be played fast and loose. For example, Nina Totenberg says, we cannot have stare decisis, fixed, established precedent for Plessy versus Ferguson. Oh, no, Brown overturned that. On the other hand,
Roe v. Wade.
Roe v. Wade.
Yeah.
We've got stare decisis. We must have it.
Sure. So the common law is long and old. We can trace it back to the 11th century and the Norman invasion of England, but the understanding of the common law is that it exists from time out of mind or time immemorial. And so it is essentially untraceable back to any origin. You can do a genealogy, but you can only go so far before you lose track of where the sources of these rules and principles are, where they're located. So someone like Nina Totenberg is writing from a perspective of 3 centuries of constitutions. So constitutions are phenomena that develop in 18th, 19th, and 20th century. And they are really, really, really late in comparison to the common law. So what we do in a common law system after the advent of constitutions is very different from what was done historically. Now we do have what I just referred to somewhere in the paper as a constitutional superstructure that frames the parameters within which we can operate, and we have to look to the Constitution, and we're building precedential cases on the Constitution, but you have different takes on what the role of stare decisis is when you're interpreting the Constitution, whereas the common law was interpreting rules and human relations and adding to the sum of decisions interpreting an unwritten constitution, Britain's unwritten constitution, sort of the character of the British people, but that's a very different process than what we've had since in U.S. constitutional law, so to speak, which is now a study of the U.S. Supreme Court cases and how they interpret the Constitution. That's a different thing. So what we have in our system reflects sort of the common law, but it's different. It's because of its period of development after constitutions. But that's a good question.
You're saying case law trumps common law.
I'm not sure I'm saying that. I guess I want to draw a distinction for a moment between the historic common law as a phenomenon that exists and the common law as a procedure, doing common law judging. So common law judging would be following practices like stare decisis and adhering to precedent and things like that. It's just done differently when judges in a constitutional system believe that the precedent is based on a line of cases that got it wrong, in which case there needs to be a reason to go back and overturn them, which is what happened with the Dobbs decision and Roe. The Supreme Court determined, with Justice Alito writing for the majority, that, okay, the court got it wrong in Roe, Therefore, we're going to erase this line of precedent emanating from Roe, and we're going to start from scratch, and we're going to decentralize this rule and let each individual state determine how it works. So I think each individual state has its own common law system and will have its own rules that develop differently from different states. So you could have rules and principles in Alabama, my home state, that are different from the rules and principles in, say, a terrible place like Vermont or Hawaii. Yeah.
Your presentation reminded me of one of John Hassis's papers. It's called The Depoliticization of Law, in which he argues that the common law, that you get true rule of law, where, I mean, what we call rule of law, it can't happen if we have legislatures, because there's some central authority making decisions, which he argues that the common law judges making these decisions in a decentralized way don't necessarily, or they can be ignored if people don't think like this is the proper ruling. How much is that part of understanding the common law, that you should think this is completely absent from legislatures? It seems like these cases you mentioned, well, it's not totally divorced from legislation, you gotta interpret that, but it seems like the realm of law has to be much more limited if there's no legislature. Then suddenly law only arises from disputes of certain sorts.
Yeah, no, that's really good. And it reminds me of an important fact, which is that people weren't calling it the common law in like the 12th and 13th century. They weren't referring to like, oh, we're doing the common law. No, that term actually arose because you had jurists going around the realm trying to figure out what's the law up here? What's the law over there? What's the law down here? Look at what these different jurisdictions each have in common. They have in common this particular rule, this particular principle. Therefore, there must be something significant and special about this generality that is binding across all of England, and that's what the common law. So you have people like late in the game, Blackstone, but then earlier people, you've got Maine and you've got Coke. Coke is one that really popularized this notion of the common law and really valorized it and popularized it and mythologized it. But statutes were incorporated into the common law. Different promulgated laws got incorporated along the way. And by the way, the common law isn't always yielding the most freedom-friendly results, because the doctrine of sovereign immunity that you talked about, you referenced, that notion of royal prerogative, that comes from the common law, that the king can't be sued. You can't sue the state. So, you have a police officer and they're maybe acting irresponsibly or however, but you can't sue that police officer because he's actually acting as a functionary of the state. And there's some analysis of whether you have absolute immunity or just qualified immunity, the latter of which, is if you're operating within the scope of your prescribed duties, then you will be absolved of liability. But if you exceed the scope of your duties and something bad happens, then you can be sued, either prosecuted or sued civilly. The common law is not always just this yielding this glorious thing, but in general, as a theory, I think that it does a good job and traditionally did a good job of protecting the rights and liberties of human beings in England and in other places where the common law was exported, which is about a third of the planet. Yeah.
So how quickly can it evolve? You might look at common law and there's a cause of action or remedy for stealing someone's horse or for punching someone in the nose. But today, calling someone a pedophile on social media, millions of followers, might cause far more actual harm, loosely defined, than stealing one's horse or getting punched in the nose.
Yeah, so I would say that the law responds to technological changes that are developing outside of itself. If you think of property law and the way people try to apply the principles of property law to intellectual property, or if you take the old Roman master and slave law and you translate it into agency law today, where it used to be the master was liable for the actions of his slave that caused harm if the slave was going outside the scope of his duties, in the same way that now you have agents and principals. Coca-Cola may or may not be liable if its driver hits a little girl when it's driving through the neighborhood. It sort of depends, who's going to be liable. The driver the driver individually is going to be liable if he was, doing stuff that was beyond what Coke wanted to do. But you can still get vicarious liability on Coke. You can still sue Coke if the guy was doing exactly what Coke told him to do when he hit the girl. Now Coke's vicariously liable. So, it's hard for, I don't know exactly how to answer that question other than we sort of reformulate ancient principles for new circumstances because those are the only ways we know how to deal with problems. We look at a problem and it comes up, we're like, gosh, this is an issue of first impression, at least in terms of facts or technology. So how do we apply doctrines that we already know and that have developed for centuries to this particular setting? And we try to work it out that way, and it's a messy process, and sometimes it takes many, many years to get through it. I don't know if that's really a satisfying answer, but I guess theoretically that's what's happening. Yeah, Zach.
So as to like the spontaneous ordering nature of the common law, murder and all that, is definitely not my area of expertise. But my understanding is that what gave rise to like the phrase, traditional rights and liberties of English.
Yes.
Stuff like that.
Yeah.
I'm just curious if you could speak to some of the, I guess what seems to me at least, the conflict between this approach to where rights come from versus sort of a more Lockean, we have these natural rights that are universal for all time and all people versus, these rights emerge specific to this culture and this time period.
Yeah, I actually don't think there is a conflict. I think that Locke if you look at the chain of documents from Magna Carta, English Petition of Rights, English Bill of Rights, all these different documents that are basically reiterating principles like due process. I think due process is in clause 39 of Magna Carta, and it gets reiterated throughout different cases, of course, but throughout big landmark documents and gets enshrined in different different cases and even statutes. I guess the thing about Locke that maybe is different is, I wouldn't say the introduction of social contract theory because he's not the first one to do it. Obviously, he's engaging with Hobbes and there are many other people doing it. But that social contract theory becomes really a formative basis for constitutional law and the creation of constitutions. And after that, you're still able to do common law, but you do it in a very different way than it was done for several centuries prior to those. Well, thank you. Thank you very much, everybody.